Roberts. Have I got counsel present for Velocity?
Stuart Markadis.
Okay, Mr. Markadis, good afternoon. And do I have Mr. Roberts?
Yes.
Okay. Give me just a second. All right. And Mr. Roberts, I don't know if I'll need testimony, but let me get you sworn in. Would you raise your right hand to be sworn? Do you solemnly swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Mr. Markadis, this is your motion for summary judgment, so I'll invite you to go ahead and proceed.
Thank you, Judge. The basis of this matter is an online loan from Prosper, and we allege that the defendant took out a loan with Prosper and defaulted on that loan. The account subsequently was assigned to the current plaintiff. The defendant did file an answer to the complaint, and it was just one line saying he didn't have an account with the current plaintiff. The plaintiff filed an affidavit and proof of claim. Nothing has been filed in opposition or a sworn testimony in opposition. Based off the pleadings, we don't believe there's any genuine issue material fact and requested the court grant summary judgment.
Okay. All right. Mr. Roberts, am I correct in assuming that you are not an attorney, sir?
Correct.
Okay, and that's fine. Most people in this position are in the same boat. This is a fairly technical proceeding, but I do, with Mr. Markadis' patience, I do tend to just at least check in with you. I did review the file and I saw what you had filed here. Did you have anything else that you wanted to advise the court?
I got the summons that was stamped for the 25th of the judge's signature, and I received it on the 29th. And I was wondering if I could ask for a postponement to seek counsel.
Okay. I was just going to ask you what would the basis be for the postponement. So, because you've had the case now since about earlier than that, I think. When did you get served with this? That's really when you wanted to get your attorney. June. Case has been going for a little over 6 months. So can you give me something else I might be able to work with, or a reason why you haven't looked at it until now?
I have the packet that I got initially, and there's no case number on here. There's just plaintiff, John Robert, plaintiff, Velocity, and John Roberts with no case number.
Okay.
On the 29th, I received like the statement or the summons for today with your stamp on there for the January 25th, 2021.
Okay, that's just the order to appear by Zoom.
Yeah.
That's just an order that we're doing here temporarily. It's been longer than we initially thought, but that's just a temporary Zoom procedure to let you know that don't come to the courthouse, you're going to appear by Zoom. But the case got filed on you in June, and you responded in June, and that really was the time when you wanted to consult an attorney, make any inquiries. So that's what I'm trying to get at. I understand you got my Zoom order a couple of days ago, but that's not really a substantive part of this case. The substantive stuff was delivered last June. So what else do I need to understand as far as why you haven't gotten counsel to look at this yet?
At the time, I wouldn't have been able to afford counsel.
Okay.
As of last June.
You may be able to now?
I believe so, yes.
Okay. Well, I think what may make sense is this. Mr. Markadis, as I recall, you guys are usually pretty open to speaking with people in Mr. Roberts' position about whether anything can be worked out, et cetera. Do I have that right, or am I putting words in your mouth?
No, Judge. I mean, obviously, we prefer to settle. I mean, that's how most of these things we prefer to end. What I
might suggest then to both of you gentlemen is this. Mr. Roberts, Velocity, as represented by Mr. Markakis, they've tagged the bases they need to in order to get a judgment here today. But as Mr. Markakis just referenced, a very good fraction of these end up getting worked out, either because the person in your position gets a lawyer to help them work it out, or because they work it out on their own. It's entirely up to you. Obviously, if you can afford counsel, that's always nice to have. But I'm also mindful that those funds for counsel might also just be able to go directly to a settlement. So that's a decision that you'll make for yourself. But what I'm proposing I would do is that I would indicate what Velocity is saying today is, Judge, no controversy has been raised here. We filed what we need to show that there's a debt and that it's owed and what the amount of the debt is. And I agree, the legal phrase is there's no genuine issue of any material fact that's been raised by you at this point. So I'm inclined to indicate, Mr. Markakis, that I'll grant your motion, but then what I'll do is I'll simply indicate that I'll sign a judgment when I get it, but I'm going to encourage Mr. Roberts, as soon as he hangs up with me, to maybe call you and explore what his options might be. If you all can make an agreement, then I'd far rather sign an order that adopts the agreement rather than the judgment. But if you all are unable to, then Mr. Markakis will afford me a judgment. And Mr. Roberts, if you want to consult an attorney, I might, Mr. Markakis, unless you have a strong objection, I might just handle that this way. I'll make a note to myself that even if you say, Judge, we were unable to settle, we'd like our judgment, I'm just going to hold for 10 days on actually signing and filing the judgment in case Mr. Roberts consults counsel and raises something. But if I haven't heard anything in 10 days, then whenever you send me a judgment, I'd sign it and file it. What do you think about that, Mr. Markakis? It's kind of trying to have my cake and eat it too.
Yeah, Judge, I don't know if that's necessarily just an attorney appearing on the case is grounds for a judgment to not be entered.
I agree. It would have to be an attorney coming in and raising some motion. I agree with you. I would be inclined to enter the judgment. I just was going to hold it basically as a courtesy to let you guys talk and let Mr. Roberts, he's behind the 8 ball now time-wise. He's going to need to hop on this today.
Judge, if I have another suggestion, maybe the plaintiff can just hold submitting a judgment for 10 days to give us an opportunity to see if something can be hashed out.
Even better. That's fine if you're willing to do that.
Yeah.
Then see if y'all can settle and or if an attorney's going to get in. But Mr. Roberts, I'm denying your motion to continue, but I'm giving you a bit of a safe harbor there. But you'd have to act very quickly, and the attorney's going to have to review things to see if you've got a viable defense here. They'd have to do that quickly, and that's possible. It could be done, but also I'm giving you a little space to just see if you can work something out that might also be agreeable to you. Either way is fine.
Okay. Judge, may I ask for Mr. Roberts' telephone number?
Sure.
Yeah.
Go ahead.
239-258-6856.
Okay, great. I'll give you a call right after this.
Okay.
Okay. All right. Then I'll indicate in the minutes that the motion is granted, but that the parties will take a few days to speak, and then plaintiff will forward the order one way or the other, either a settlement order or a final judgment.
All right. Thank you, Judge.
Okay. Good luck to you both. We'll be in recess until the 2:30 hearing.
Thank you.
Okay, good afternoon, everyone. Welcome to Collier County Court. I'm Judge Martin. We have a matter scheduled for 2:30 that is an eviction hearing on Griffin versus Love. I believe I've got counsel for the plaintiff. Griffin, would you state your appearance, please?
Hi, Judge. Nice to meet you. For those I've not appeared before you, Jason Lucas. I represent the plaintiff, Deborah Griffin, in this case.
Okay, and is Ms. Griffin present with us?
Yes, I am.
Okay, so 6364 is what it says on the Zoom box, but that is Ms. Griffin. Okay, and then I've got another square here, which is labeled Love. I've asked them to unmute. Okay, are you all, is it Mr. and Mrs. Love, Chris and Donna?
Yes, ma'am.
Okay, so good afternoon to you all as well. Let me ask Ms. Griffin and Mr. and Mrs. Love, would you all please raise your right hand? I'll get everybody sworn in at once. Do you all solemnly swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, very good. So you all can put your hands down. And I have reviewed this file. I understand this is a suit for eviction, Mr. Lucas, based on the expiration of a lease. Is that right?
That's correct, Judge. And I'm sure you're aware, and I'm not sure if you know, we had filed a motion for judgment on the pleadings. Once I had reviewed the defendant's answer, I'm not sure that anything was disputed within it. So I had filed that motion, contacted your office, and also was told that I could schedule a motion for judgment on the pleadings. I guess to go before the evidentiary hearing, just simply just because I think it would probably save plenty of time. So I wasn't sure if we could do that first, or if that was your preference. Like I said, I haven't been in front of you, so I wasn't sure how you prefer to run these things, but it seemed to me it would cut off a bunch of testimony and time.
Yes, I am aware of all that, and I did want to engage in that in some preliminary discussion, and then we'll take testimony.
Sure.
If we need to. Let me start from this angle. I have read everything, and I do understand from Mr. and Mrs. Love that this is pretty distressing. I can appreciate it's probably pretty distressing for Ms. Griffin as well. I know you've got letters from neighbors that you're good people and all of that. And I start every hearing believing that everybody's a good person. That's not what I'm here to decide. But I do have a bit of a hole here we're going to have to figure out how to navigate. At the end of the day, I can't, with very limited exceptions, I can't force people to house other people if they don't want to. And it sounds like y'all had an agreement, you had a lease. That lease had an end date. Of course, there's a pandemic going on and everything's crazy. Ms. Griffin probably didn't start out planning to live in the house, but I understand that she may have come to live in the house after the lease expires. My question to everyone is this. I'm fully prepared to hear everybody out if that's what we need to do, but I am curious as to whether there's any room for us possibly to negotiate a settlement. And I'll tell you exactly what I mean by that. It means both sides get a little less than what they want usually. But what typically happens in an eviction settlement is that the parties agree on a firm date, a deadline by which the defendants would be out. And as long as the defendants meet the deadline and get out, the case goes away and they don't get stuck with an eviction on their record and so forth. But if they blow the deadline, the plaintiff gets a final judgment of eviction and a writ of possession immediately, no further hearings, no further anything. Mr. Love is signifying he's open to that. So the part of the reason why I would do that, and I do need to let Mr. Lucas know this, I do see possibly some technical infirmities here. And I want to sort of state that at the outset, it's possible that the plaintiff will overcome those technical issues and prevail today, in which case Mr. and Mrs. Love might be out of that place in the next 1 to 2 days. But it's also possible that I might ultimately, after I hear people out, conclude that the technical problems are fundamental and have to basically send Mr. Lucas and Ms. Griffin back to square one to start over. Now, if I do that, they'll fix the problem and they'll get their eviction. So that's never a great option. And that's why I always come in gently and say, both sides have something to gain here. Both sides have something to lose. And if there is a reasonable date, it's probably not going to be next year. It's probably not going to be 6 months from now. But if there's a reasonable date relatively soon that you all might get out, if the plaintiffs agree, then the plaintiffs can save some time, some money, some hassle, some risk. They can have certainty. Hang on, ma'am, don't interrupt me. They can have certainty and enforceability. And then again, the defendants also would have certainty, the ability to try to navigate that. Ms. Love, there was something that you wanted to say.
Oh, I was talking to my husband. I'm sorry about that.
Very good. That's fine. Mr. Lucas, I guess the question is best put to you as the plaintiff's counsel, whether you all wish to engage in that. And if, by the way, you want to speak privately with Ms. Griffin, I can orchestrate that through a breakout room. So,
Judge, I appreciate you even having this discussion prior to evidence. So thank you. I have not spoken. So just from our perspective, Judge, the lease expired September 1st, but my client hasn't been paid anything since then, which is an extreme hardship on her.
sure.
So I don't want to speak for her. I just know when she contacted me 6 weeks ago to go through with this, it was a hardship at that time, and I can imagine it's even more so now. So I mean, as long as the court doesn't mind hearing from her directly, Ms. Griffin, based on what the pros and the cons that Judge Martin had just announced, would you like to be heard on whether maybe we can give just a little bit to get this done where there's some certainty?
I actually feel like I've given all that I can give.
Okay, that's fine. What I don't want to do is have a really long settlement
Sure.
discussion that bears no fruit. I'd
Thank
rather
you.
just use the time. So, Ms. Griffin, just so you understand, it is possible that I will find that you all have not done what you needed to do, dismiss the case and make you start over. You do understand that's a possible outcome today?
Yes.
Okay, let's proceed then. Mr. Lucas, you have a motion for judgment on the pleadings, and that'll call out, I think, the legal issue that concerns the court.
Sure.
Let's see where that goes, and then we'll go from there.
Yes, Your Honor. Judge, as set forth in the complaint, Ms. Griffin owns the property on Orchard Lane. That's not disputed in the response. I would just simply point out to the court on a motion for judgment on the pleadings, as the court probably, and I'm sure very well knows, Rule 1.110E says averments in a pleading that are not denied are specifically are admitted. So asking the court to take judicial notice of the court file, including the pleadings, I think a fair reading of the complaint, which sets forth the elements of the tenancy. It attaches a lease agreement, which was signed by all parties. That wasn't disputed in the complaint. It was expired on September 1st of 2020. I didn't see any denial of that in the complaint. I think, Judge, in reading it, I read it again in preparation for today. The essence was they thought that they were going to be extended, not that there was a subsequent writing or an extension or any money paid after the expiration of the lease. I think, obviously, as the court had pointed, has recognized, things during the pandemic are tough, and people need to make adjustments to their life. The adjustment that Ms. Griffin wanted to make was just simply moving back into a house that she owns after the tenancy that she honored had expired. I had made some highlights in the answer, in response to my complaint, but they look more like we thought we were going to get more time. We need more time. We're searching for a place, not that A, there's no lease, or B, that the tenancy is not technically expired. So I think a fair reading of the answer, Judge, just simply wouldn't lend the court to denying my motion for judgment on the pleadings because the material elements of the complaint are not denied, and I think that's very clearly set forth in the motion for judgment on the pleadings.
Do I, Mr. Lucas, in a motion for judgment on the pleadings, I am, if I recall correctly, I'm to essentially accept as true everything stated in the complaint as well as everything stated in the answer, and then determine whether we've got a cause of action that survives that.
Yeah, yes, Judge, and I think we're just, I don't disagree with that, except I would point out, certainly, we're here just simply for possession. If the Loves, and I'm not suggesting they do, and obviously not to the detriment of my client, but if the Loves had any claim for damages based on the interactions of the parties after expiration of the lease, it's not an issue of possession. It would just be simply them filing some sort of monetary complaint.
Well, let me, and I'm sure the Loves have a response, but this is a technical legal question, so I'm going to just respond to Mr. Lucas and put my cards on the table as to what my concerns are.
Sure.
In looking at, both sides are doing the best they can here, but in looking at this lease, which forms the contract, it's a very simple lease, it's one paragraph.
Yeah.
And in looking at the answer and assuming everything is gospel in both, I've got a lease that goes March 1 to September 1. And I then have, per the answer, the plaintiff moving in. And in the answer, I have the plaintiff making assertions that they can stay and that rent is waived. And in order to proceed with the eviction, what plaintiff would have needed to do here is communicate clear notice that they are terminating the lease. As Mr. Lucas knows, the lease has by its terms an expiration date. But should the parties decide to allow the tenancy to continue beyond the written lease, then what we have is an oral month-to-month tenancy. And on the answer, I have assertions which have not been denied by plaintiff. I have assertions that plaintiff allowed them to stay, and further that plaintiff waived the rent. Now, Ms. Griffin, that may not be true at all. But again, on the technical pleadings, what I have, Mr. Lucas, is an eviction which does not have the proper statutory notice to terminate the tenancy before you can pursue the eviction. And the waters got muddied.
Sure.
Here. What really, in best practice, what should have happened is that prior to August 15th, Ms. Griffin should have sent a letter that said, just a reminder, the lease expires and you will have to be out September 1. Then we would have a clear lease termination and she would be ready to sue September 2 for eviction under holdover if they stayed in. But there is no notice in your complaint, and the four corners of the lease have clearly been extended by the actions of the parties.
Well, and Judge, I would, that's only for the motion for judgment on the pleadings. Obviously, we didn't do that because we know those facts not to be the case, and we can put on evidence of that. So I understand what the court is saying, but they were given notice or told to leave well prior to the expiration. That's why notice of non-renewal was not required. They just never left.
So there, was there or was there not ever a written notice communicated to them?
No, and Judge, that's only if my client would have, by anything that she done, extended them or created a tenancy beyond the expiration, which, from the testimony we'll provide, she never did.
Okay. Well, I'll have to evaluate that testimony. But again, I come back to the possibility.
We understand
that I'm going to have one person who says, I never said that. And I'm going to have two people who say, you absolutely said that. And I have to find that there was notice here. So I come back to, are you sure you don't want to just try to fix a date and time where everybody agrees to get out. And if the answer is no, it's okay. I'm going to hear the testimony and I'm going to weigh the credibility, but it's a dicey little scenario that y'all are in on both sides.
Judge, reading between the lines, and thank you for indulging us. I would like to speak with my client. I hope that the court would maybe agree with me and maybe communicating to the Loves. If we go forward today, for whatever reason the plaintiff loses, we can give notice today requiring them to be out February 28th. So that would be our worst day, if a notice of non-renewal. So from our perspective, to communicate to the Loves, if we win, then they're out pretty immediately. So if I can get them based on that, maybe to meet in the middle, I'd be happy to try to convince my client of that.
And that's precisely why I'm driving this way. And I don't mean to suggest that I might not entirely adopt the plaintiff's version of events. She may prove to be the most credible witness here. So don't despair, Ms. Griffin. But I'm just trying to make sure, in an effort to be fair to both sides, that both sides know what they have at stake. Mr. Lucas is exactly right. If he's worst case scenario, if he's forced to go all the way back to the beginning, he will nevertheless quite likely secure an eviction in 30 days or less. What I was going to suggest, and we haven't talked about this yet, is, if the Loves are able to get out, to get themselves out much faster than that, it could provide an incentive to Ms. Griffin to say, well, let's talk. Just what is your best hope, Mr. and Mrs. Love, at being able to get out of there just as quickly as possible? Remember, you're trying to get Ms. Griffin to agree here. What do you think you can do in terms of vacating?
I don't know if you want me to go back to August or just overlook that and answer your question directly.
Yeah.
I'm looking maybe 30 to 45 days. We have been looking diligently. I've been dealing with real estate agents as well, helping us look. It's very hard during a pandemic right now.
Sure.
And I know you know that. 30 to 45 days, we're willing to, do our best, and that's it. That's all we ask. We understand the situation and we're trying to cooperate. Like I said, there's things I can go into, but out of respect for the court, I know you just want to cut this simple, and so do we. We want to get on with our lives. 30 to 45 days.
All right. Well, and yes, I'm not wanting to dig up a lot of bad feelings. If we've got a chance that people might come to an agreement, digging up the bad stuff won't be helpful.
I understand.
30 days is right about how long it'll take, even if they lose today, to turn around and win this case. So I think Mr. Lucas was suggesting something more in the ballpark of 2 weeks, although Ms. Griffin, I don't know that she's bought into that yet.
I don't know that she's bought into that, Judge, but I'm not sure that the Loves understand that it would be no more than 30 if they won today. That's why it's got to, I was hoping to kind of split it.
We have to find middle ground.
Yes.
Yeah. If the agreement is already the plaintiff's worst case scenario, they don't gain much by making an agreement. That's just the difficult reality of it. Now, Mr. and Mrs. Love, if you're saying, look, Judge, I can't get blood from a stone, I can't be out of here in less than 30 days. Okay, we'll proceed with the hearing. I will weigh the testimony. I try to see what I can do to get an imperfect resolution for both sides, as opposed to a perfect resolution for one and a disaster for the other.
I understand. If you're looking for me to answer, 30 days, we'll do our best and let Ms. Griffin know that her house is totally secure. We never had any intention upon making it a loving, beautiful home from turning it inside out. Okay. So I don't want her to worry in that respect. But back to your question, 30 days would be
30 days. Mr. Lucas, do you all want to proceed today, or do you want to craft an agreement for certainty at the end of the month that there would be either a vacation or a final judgment without any risk?
Miss Griffin, would you just simply like to proceed today?
Yes, I would.
And Mr. and Mrs. Love, you understand if we proceed today that it could be fairly immediate, not the 30 to 45 days you were asking?
We're asking for 30 days because, like I said, we have been looking diligently.
Yeah,
Okay, and I believe Ms. Griffin knows within our heart that we have been.
yeah.
And
She
like
knows
I
that.
said, it's been a few months, and with this pandemic and a lot going on, and my husband lost his job, we are trying. We are trying. So I don't want to make any promises. I don't want our faces to look bad, but I can't make promises to you.
Judge, I
30
think we should probably proceed today, Your Honor.
That's fine. What I'm going to do is this. I'm going to, for the record, I'll deny the motion for judgment on the pleadings for the reasons that I had stated, and I'll invite the plaintiff to go ahead and put on their case for the final evidentiary hearing on eviction.
Thank you, Your Honor. Judge, may I proceed?
You may, and all witnesses have been sworn, so you may call your first witness.
And Your Honor, just prior to that, I did kind of ask, and I'm not sure the court, would the court take judicial notice of the court file? I think there was no denial of the lease between the parties, at least, so just for that purpose.
That's fine. I will do that. So to translate that, Mr. and Mrs. Love, the documents that are in the file, I'll be relying on. Both sides are free to talk about what those documents should mean and so forth. Okay?
Yes, ma'am.
Okay.
Mr. Lucas.
Thank you. Ms. Griffin, I'm going to call you as a witness. If you would state your name for the court, please.
My name is Deborah Ray Griffin.
And Ms. Griffin, do you own a single family home located at 4264 Orchard Lane, Naples, Collier County, Florida?
Yes, I share ownership with my sister.
Okay. And did you execute the lease with Mr. and Mrs. Love, the defendants in this case that's attached to the complaint as Exhibit A?
Yes,
Okay. And to your knowledge, that lease expired on its face February 1st, 2020, is that right?
yes.
Was any written agreement between the parties extending that lease ever executed between any of the parties?
No,
In August of 2020, did you verbally tell the Loves that their lease was close to expiring and that they needed to leave?
I told them that I would be moving in, and that's why we weren't going to make another lease.
Okay. Did you ever have any conversations with them either prior to the expiration of their lease or after it expired on September 1st that ever extended their tenancy where they were allowed to remain, or did you ask them to leave?
No, I actually let them stay because of COVID. I had no idea what that I would be getting myself into at that point, but it didn't take me long to find out.
And when you said you actually let them stay, that was not in exchange for rent. That was just simply as a courtesy to them and as a matter
As a
of convenience.
courtesy, that's right. So they could save money and get their own place.
So there was no expectation or requirement for that extra time that they would need to pay you any money. Is that correct?
No,
Okay.
no.
And since September 20th, since September 1st, 2020, have they paid you anything for rent in any way?
No, they did contribute $380 toward the electric, and that's it.
But that was not conditioned upon any new verbal or written lease, was it?
No,
Okay. And when you asked them to leave after September 1st, what were you told?
that it was going to be hard for them. They really took it badly. They really took it badly and were not willing to work with me on it. They had every intentions of staying. That became obvious.
You never agreed to that?
No.
I'm sorry, Mr. Lucas, what was the time frame of that last couple questions you were just referencing?
Judge, August, I'm sorry.
I guess
Ms. Griffin, I'll ask Ms. Griffin. Ms. Griffin, when was that time frame of the last conversation when they took it badly?
It was right after I moved in October.
Okay.
We were trying to work things out, but by the time Thanksgiving rolled around, I actually gave them a date that they would have to leave. I didn't do it in writing, but I told them January 1st.
Okay, I guess the main issue and what I really want to ask you about, the extra time after September 1st, that was not an extension that required the payment of rent. That was simply giving them a little more time to get out because of COVID.
That's right. That's right, because of COVID.
And are they still in possession of your property?
Yes, they are.
Judge, I have no further questions.
Okay. All right. Mr. and Ms. Love, you have the ability, if you would like, we'll ask which one of you is going to be the spokesperson, but you could ask questions of Ms. Griffin in what's called cross-examination. Either way, you're going to get to tell me your side. So I just want to know if you have any specific question that you want to ask of Ms. Griffin.
First of all, Your Honor, I'll be the spokesperson if that's okay. My husband's right next to me, as you can see. Do you want me to start from the beginning? I don't have any questions for Ms. Griffin.
That's all I want to know. So, okay, you have no questions for her. Hold your side of the story for a moment. Mr. Lucas, does the plaintiff wish to call any additional witnesses?
No, Judge.
Okay. So plaintiff rests. Okay. All right, then, Mrs. Love, I'm going to turn to you and your husband. I'll let you go ahead at this point. I don't really need to know all the stuff that was in your 7-page answer. I read all of it. I understand that you all have put a bunch of money into this place. I frankly don't know why, if you don't own it, you did that. But it doesn't, unfortunately, have any legal impact on what we're doing. So I really want to focus on why you stayed past September 1 and what was communicated about if you could stay, what the requirements would be.
Okay, ma'am. Ms. Griffin had told us in the beginning of August, when I went to her house the beginning of August, I had paid August rent. I asked about her lease renewal for another 6 months. She had said she would think about it or work on it. I can't quite remember. At the end of August, she had came over when I had September's rent, and she said she was moving back in as of October 1st. But she promised me that she would work with us. She's not going to see us on the street. She knows how much we love the house and how much hard work, which is totally irrelevant. I understand that. But she didn't want to see us in a position. She was hoping one day that we'd be able to buy it. During COVID, my husband's job loss, it was nearly impossible for us to make a purchase at this time. So when she had moved in, like I said, she was willing to work with us. Everything was going great. I did give her money for water and electric. She did want us to save money. Right before Thanksgiving, we were sitting on the lanai, and she had said to me out of the blue, I think you need to be out by January 1st, because at that time she was thinking about selling the house and told us that she wanted to sell it on her own with nobody in the house. I had said, okay, well, I'm going to shoot for that, but I can't guarantee that. Back then, we've been looking as well, trying very, very hard to do what we can do to move. Other situations arose. It was becoming more difficult. We had people cancel on us because of COVID while looking. It was just a matter of believing her and trusting her word. No, nothing was in writing. I just trusted her that we would be okay. Then all of a sudden, things turned. I know you don't want to get into the blah, 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 and I can respect that. But I did tell her we're going to need more time than January. I could tell you right now. She moved back in October 1st. She moved out January 1st. We haven't heard from her. We haven't seen her. She moved in as fast as she moved out. So all of a sudden we get this letter from the lawyer and these judgments sent upon us when she knew our situation from the beginning. And all I asked her was for more time, cutting our losses. I apologize for everything. We're going to need at least another 30 days because we are trying. I don't know. I think my husband wants to speak. I don't know if you want him to speak, but that's all we're asking is for some more time. That's it. I cannot be on the streets during COVID.
You also got to put in the factor of we were going to be selling the house too, and I put a lot of time and money into it because she said collect all the receipts and we're going to be putting towards to the house. We have all the receipts. Never. I'm just saying, and also, so that factor was we had a friend of ours. The time frame wasn't supposed to be moving out. I was supposed to get the work done before January 1st.
I would just object to the relevance of this line of
Okay,
testimony.
but still, and then we were going to look for a thing.
Let me interrupt you,
That's
Mr. Love. I'm sorry.
Yes, I'm sorry.
Well, it's so I've got
I
another
know.
hearing. I've got another hearing at 3 o'clock, and it looks like they're
Yes,
on the
ma'am.
wrong. They're on the wrong Zoom link, so I've got to move over.
We're just asking for more time.
We're just
That's all.
asking for a little time. That's all.
I get it. I get it. So,
Yes,
Mr. Lucas, in listening to the testimony, we've got another new, different technical problem that comes up.
Sure.
Looking at this, hang on, Ms. Griffin. I listened to everybody tell me what they wanted to tell me, but Ms. Griffin herself said she let them stay past September 1.
Judge, I don't doubt that, but it's only a renewal of a tenancy if the tenancy is either verbally or in writing, where, hey, we're going to pay rent and you can stay, or if they pay rent. There was no rent. It was like, hey, we'll let you move out a little late because of COVID. That's not an extension of the tenancy.
I get
I
it.
think that's the distinction.
And really what it is a detainer after that point. So we've got a Chapter 82 problem that's been pursued as a Chapter 83 problem. I don't have a notice of termination. That's why I was kicking the tires here, trying to figure out what the legal basis was. And there may well be a legal basis. It just isn't the one that you asserted.
Judge, without the court making a final ruling, could I ask that the court adjourn this? That way Ms. Griffin's not being charged an additional filing fee. Ask for leave of court to amend the complaint. I'd like to be able to cover all the bases so the court is not loath to deny her relief, having not received any remuneration for the situation that she's currently in.
Well, and I think that's probably a fair request, and we can do that. Take one last swing at it.
Sure.
Is there any chance that both sides would agree that they get out in 2 weeks and then nobody has to jump through any other hoops?
I could agree with that.
Sorry, Ms. Griffin?
I could agree with that.
I don't know if Mr. and Mrs. Love want to back down, but Mr. and Mrs. Love, you don't ultimately have a position of strength here. I haven't decided what I'm going to do. You could be out in the next 1 to 2 days, or you could have an agreement to get yourselves 2 weeks and at least avoid having a judgment against you. That I don't want to overstep. I don't want to twist your arm, but this is a very unusual situation, and it's unusual. I will say this because I think Ms. Griffin and Mr. and Mrs. Love have been trying to do right by each other. I think you've all been trying to do the right thing. Ms. Griffin, what else do you want to say? I need to get to my 3 o'clock hearing.
Okay, I have to say the reason I left so suddenly is because I was actually afraid for my life.
All right,
Love
that's
got violent.
Let's not talk about that now.
That's not going to be helpful. I
We
just
are
need to
here.
know whether, oh good, my people from 3 o'clock found me in the different Zoom room. I just need to know whether we have an opportunity here to do something that avoids further court and attorney's fees and so forth, or if we need to take the long way around. If we can, we will, but it's more expensive. Mr. and Mrs. Love, you all can be charged the attorney's fees here. So I know it's difficult, but you've got a bad choice or a worse choice. Which one would you like to make?
Is it
Whatever my
possible?
attorney decides.
Who's talking? I'm sorry.
Ms. Love, my question was to you.
All right, thank you, because I heard Ms. Griffin talk. Thank you. Is it possible to ask for 3 weeks? I will settle for 2 weeks, but I don't want to disappoint anybody.
No, because you're not understanding the negotiation. There's no benefit to them after 2 weeks. There's no incentive to them. It's not a useful negotiation. So
Okay, so 2 weeks, we have no judgment, and that'll be it.
that's what I'm proposing both sides strongly consider. So we'd say end of the day on February 15th, 5 p.m. February 15th. And if you all are still there,
we'll do it if they do, Judge.
okay. If you all are still there as of 5 p.m. on the 15th, then Mr. Lucas, morning of the 16th, files an affidavit from his client. They blew the deadline, and he gets a judgment on the 16th, and you're out. But that way, at least, there's no judgment if you all can expedite trying to relocate. It's a bad outcome either way. I respect that, but it's better than the alternative.
Yes, ma'am. We'll go ahead and take
We'll
that.
go ahead and take the 2 weeks, and thank you, Your Honor. You've been wonderful, and we thank you for your time.
Judge,
Mr.
I
Lucas-
appreciate your efforts. Thank you very much.
Judge, you're great. You were a good judge, and I like your smile.
Judge,
Well, thank you. Mr. Lucas, the least I can do for you is I'll take care of the order. I do have one for these occasions. It's coming up quite often.
thank you.
I'll do an order. 5 p.m. Monday, February 15th is the deadline. If they're out, the case is dismissed. If they're still there, there's a judgment just as quickly as Mr. Lucas can walk it through the next morning.
Yes,
So
ma'am.
hopefully everybody can get through this. I know you're doing your best. It's hard, but I thank you for your efforts today, and I wish both sides good luck.
Thanks,
Yeah.
Judge.
Thank you, Your Honor. Have a good
Thank you
day.
very much.
Okay.
Thank you, Judge.
Good luck, everybody.
Thank
Okay.
you.
Thank you,
Bye.
Mr. Lucas.
That'll bring
Bye.
me to the 3 o'clock hearing, which is Poinciana versus Zaval. And I noticed that it looked
Sure,
like
make sure your case is off.
got the wrong information from my office. I saw Mr. Allen try to log on to the morning session.
Hold on. You're still on with us.
No, you're on with me. There, I love the mute button. All right. So I saw that, Mr. Allen, that you were trying to get on, and it looked like maybe my assistant figured it out and got you the right information.
We did. Thank you, Your Honor.
And it looks like Mr. Zaval is on as well. I'm going to ask him to unmute.
Yes, ma'am. I am present along with my sister.
Okay. Now, are you able, Mr. Zaval, to do video so I can swear you in if I need to?
1 second, please.
Judge, I'm not sure that swearing him in will be necessary. I need to just update the court on the status of the case.
Sure, great. Go ahead.
So a couple of minutes ago, we literally 15, 20 minutes ago, Mr. Zaval signed a settlement agreement with the association that sort of mirrors what happened in that last case.
Okay.
He's going to be able to stay in the property until March 3rd. And if he's not out by March 3rd, the settlement agreement says that I can come back to the court and ask for the issuance of a writ of possession.
Okay.
So
Okay.
that's kind of where we're at right now.
All right. Well, I appreciate the hard work. Mr. Zaval, could you hear Mr. Allen, and does that reflect your agreement?
Yes, ma'am. I received the agreement. I did sign it. Did you have a chance to review it?
I haven't. Mr. Allen will be sending it in to me, but as long as that's your agreement, then I will just look for that, and I will enforce that. As long as you're out, you're in good shape.
Yes, ma'am.
If you're not out, then he can get what he's asking for without any further hearing, okay?
So, yes, the agreement is consensual, agreed upon by both parties. And, you know, I'm not alleging anything by no means, but there will be no kind of intimidation or
Great.
threat, anything like
Good.
that.
Good.
Good.
All right, well, that's wonderful. Mr. Allen, I thank you, and Mr. Zaval, I thank you for your hard work to come together.